Hello.
Audible, sir, you are audible.
We can hear
Okay.
you, sir, if you're audible.
Yes. Now we are starting this webinar, and the topic of first of all, I am welcome to our guest of speaker, Prachi Johiji, and other participants. Most welcome. And the topic of the today webinar is the interplay between IBC and arbitration. Main issue is whether a Section 9 petition under IBC is maintainable for execution and award under when a challenge under Section 34 of the Arbitration Act is pending or under process. In this regard, in detail, Prachi is acting and delimiting more efficiently. Please, Prachi, you are now co-host. Please proceed further.
Thank you. First of all, I'd like to thank that everybody is here today this afternoon, and a great big thank you to Praveen Kumarji for organizing this. And I hope to keep your interest over the next about 40 minutes, 45 minutes, and thereafter I'm open to taking any questions that may be there. Sir has outlined that the idea of this webinar is to discuss the interplay between the Insolvency and Bankruptcy Code and the procedure of arbitration under the Arbitration and Conciliation Act 1996. So sir has also told us that we will be focusing on what happens when an arbitration proceeding is pending. But I also take this opportunity that I will spend some time on discussing the interplay between IBC and arbitration during various phases of insolvency proceedings. And the intention would be to go from the pre-admission stage, whether a Section 9 is maintainable, what happens to a Section 7, what are the relevant judgments in that regard, going right up to the approval of plan and or liquidation stage. So there are various examples that have come to the fore through many case laws, and those I intend to be discussing today. Of course, not the details of each and every case law or not the facts of those case law, but a very practical approach as to what is the interplay between the two statutes and where arbitration goes once insolvency comes into the picture. Of course, we all know that so I'll begin with an introduction. I'll start with what is the IBC, what is arbitration, what is the ADR mechanism, why an interplay between the two is so crucial to corporate litigation today. So as we all know, alternate dispute resolution mechanisms such as arbitration, mediation, conciliation, these were all brought forth because of very lengthy and time consuming and costs heavy on the cost litigation procedures. So it was thought of by practitioners in the field that if there are certain disputes that are amenable to negotiations. However, unstructured negotiations are not possible, and that is why the proceedings come before the courts. So they thought of certain methods of alternate dispute resolution, which includes primarily three methods that as have been recognized by the Arbitration Act, that is arbitration, mediation, and conciliation. Insolvency Code, on the other hand, is a revolutionary new act in our country because the regime of insolvency and bankruptcy previously that we had, or the regime for the companies that we had in the country, was dealt with primarily under the Companies Act and the Provincial and Presidency Insolvency Acts. Now, the Companies Act had the provisions for winding up, which dealt with the concept of inability to pay debts. Inability to pay debt is an inherently contractual dispute. It is a dispute which retains to whether I am or am I not capable of paying the debt, what is my solvency. However, when the IBC came into the picture in 2016, the perspective was entirely changed. We stopped looking at the ability or inability to pay debts and we moved on to the regime of default. So this regime of default as it stands is not concerned with whether I have in my bank account enough money to pay the debt. So this regime of default has now brought into the picture an in rem proceeding, which is a proceeding in against the entire world, all the creditors, etc., are brought into the fold of the insolvency proceedings, even though the proceeding is initiated by one creditor, for example. So that is the inherent difference between an arbitration procedure, which is a contractual remedy, which is a remedy to decide the dispute in terms of a contract, whether or not certain monies are payable, how those are to be paid, certain invoices are payable, etc. The regime in insolvency is that of default. Now, since if we look at the insolvency of companies under the Insolvency and Bankruptcy Code, it is an inherent part of corporate litigation in our country. Now, corporate litigation has traditionally been answered through the alternate dispute resolution of arbitration. And hence, over the last 6 years, 7 years, that the insolvency regime has developed, there is a lot of interplay between arbitration and the insolvency code. A lot of people sometimes come to us, the clients come to us, and they want to discuss what is a better remedy, to go for an arbitration or to go for an insolvency. So we have to consult and we have to then tell our clients what is the difference between the two. How one will lead to a recovery mechanism, while the other is a much larger mechanism where recovery will eventually happen, but for all creditors. And the one of the more interesting aspects of insolvency regime being brought in view of already existing corporate litigation regimes like ADR, is to be found in the UNCITRAL legislative guidance on the laws of insolvency, which is applicable to the entire world. And our insolvency code takes heavy influence from the UNCITRAL guide. So the UNCITRAL legislative guide has 3 paragraphs in its report, which mentions that the idea of an insolvency regime of the sort that IBC is to deter individual creditors from exercising individual reliefs. The idea is that a larger collective relief be obtained by creditors instead of each individual going for certain kind of relief against a corporate debtor and then obtaining something for themselves. So it is not that a share in the pie be obtained by each creditor on their own through various proceedings, but that the entire pie be distributed in an equal manner to all the stakeholders, even though the default may be in terms of a few creditors. So, in this background, the arbitration influence is very large because the inability to pay debts or the default is decided in arbitration also. But IBC is a much larger in rem proceeding where the entire pie gets distributed instead of each creditor being able to obtain some small parts of it. So this is the background. This is where I see the arbitration and IBC interplay becoming very important in this regime, especially for stakeholders such as corporate debtors, such as the directors of these corporate debtors, and such as the financial creditors and operational creditors, because they have to ultimately take the call whether they go for a larger in rem proceeding where they may be able to get a collective relief, or whether it is in their interest to take a small share of the pie and be satisfied with. Now, I have divided my time into 3 parts. I will first deal with the pre-admission stage and the interplay and arbitration in that, which I am going to focus on a little bit extensively on the fact that when can arbitration proceedings be admitted? What if there is a section 34 that is pending? Section 34 is a challenge to the arbitral award. So what are the factors to be considered? What are the judgments that have been passed this far? Second part would be to consider what happens once there is an admission of insolvency. In this part, I will discuss what happens when there, because of the moratorium that is imposed, what happens to pending proceedings, what happens to counterclaims, and also I will discuss a little bit about the perspective of the resolution professional as to how the claims are to be admitted. And in the third part, I will discuss what happens when there is a resolution plan, or if there is no resolution plan, there is liquidation, and the interplay of moratorium, arbitration, liquidation, and execution of arbitration proceedings. So I'll directly come to the first part where I intend to deal with the pre-admission of CIRP stage. Now, as I have said, the idea has always been, and the guiding factor for the insolvency law has been, that there is a collective relief which can be claimed for everybody. Even if the claim by way of a Section 7(9) petition is made by a few creditors or one creditor, the idea is that of a collective relief for everybody. So the assets have to be protected. They have to be collectively distributed to all the stakeholders in insolvency regime. In arbitration, inherently, it is the exact opposite, where one party says this is the agreement, this is how the agreement is to be executed, and that one party decides that, okay, this much of your asset share comes to me, or this much is my debt, which you now have to pay to me. Through an arbitrator, such decisions are reached, which is known as an arbitral award. Now, when a Section 7 or a 9 petition is filed against a company, that is the first stage of initiation of insolvency proceeding prior to admission. So a proceeding gets admitted. Now, it was discussed in Arbitration Act, there is a specific provision called Section 8 of the Arbitration Act, where if there is an arbitration clause between the two parties, then no other civil proceedings are maintainable. And Section 8 requires a civil court that is now seized of the matter to send the proceedings for arbitration. So a question arose in a particular matter, which is the Indus Biotech matter, where this question was ultimately decided by the Supreme Court as to what happens if a Section 7 proceeding is filed in the NCLT for initiation of insolvency by a financial creditor, and simultaneously the corporate debtor moves an application under Section 8 of the Arbitration Act, saying that the dispute between the financial creditor and the corporate debtor is contractual in nature, and the contract has an arbitration clause. So any other civil court will not be seized or cannot be seized of the issue and has to refer the parties to arbitration. The NCLT decided that the parties were required to go to arbitration. Ultimately the NCLAT decided against it, and the matter went to the Supreme Court. The name of the matter, I'll just repeat. It is Indus Biotech versus Kotak India Ventures Private Limited. Now, in this matter, the Supreme Court analyzed the existing law as to the dispute and difference between IBC and the Arbitration Act. The Supreme Court also analyzed the existing judgments as to a special act versus a general act. And there is some discussion on the concept in such a scenario where admittedly dispute is under a contract or the default in IBC is under a contract, then does the realm of the contract become more important than the realm of the operative law, which is the IBC? Because IBC at best is a law that is operational in terms of dispute. But contract is a specific agreement between the two parties that if there is any amount payable, you will claim it under the Arbitration Act. So this was the situation where the court discusses these. The court discusses the aspect of general law versus specific law, older act versus newer act, and the court discusses section 238 of the Insolvency and Bankruptcy Code, which says that in case of any dispute between two laws in force, the IBC will have an overriding effect. So this was primarily what was decided in NCLT and NCLAT also. However, in the facts of the case, the Supreme Court came to a conclusion that in this scenario, Section 238 loses its relevance, because in this scenario, the debt is to be determined between the parties and only thereafter will it become a financial debt. There were certain cumulative debentures that were issued in this matter, and the amount for those cumulative debentures that would become the debt was yet to be determined. So the Supreme Court holds that in cases where debt is yet to be determined, in those cases the parties will have to go for arbitration, because the debt will have to first be determined before the debt to become a claim under the IBC. Now, so what the Supreme Court ultimately held was that in this particular matter, because the debt was not yet determined, they had to first go into the arbitration. They allowed appointment of an arbitrator. However, they simultaneously held that when a Section 7 petition is pending in the IBC, in the framework of IBC before an NCLT, it does not have a conflict with Section 8 of the Arbitration Act, because the appointment of arbitrator power is not with the NCLT. The NCLT, dealing with a law that deals with stakeholders in REM, will only decide the issues of debt and default. It will not decide the issues of whether or not an arbitrator is to be appointed for recovery of the money, or they have to go into the resolution plan. So the Supreme Court categorically held that the NCLT does not have the power under the IBC to decide whether or not the parties should go for arbitration. Only observation that was made is that in the particular case, the debt was not determined, and hence an arbitration or any other valid legal proceeding would be required. So the Supreme Court made it categorically clear that there is no dispute. Now, this concept, if we simplify it a little, is something that we use in our daily lives as IBC practitioners, that the IBC is not a recovery forum. So a civil suit is not in conflict with IBC, because a civil suit is where disputes get decided, whereas an IBC is where I am not asking for my recovery, I am not asking for damages, I am not asking for compensation. I am just saying that I have this default of 1 crore plus rupees, and this 1 crore plus rupees has not been paid to me. Whether I'm an operational creditor or I'm a financial creditor, that is my limited mandate to show to the Honorable NCLT. And the Honorable NCLT has a limited mandate in Section 7 just to see debt and default, in Section 9 operational creditor cases to see whether there is any pre-existing dispute. So this concept was applied to the interplay between IBC and arbitration in the Indus Biotech matter. However, subsequently, there are certain issues that arise out of this judgment also, which are being answered differently by various NCLTs. One such issue I will delve into a little bit, which decides whether or not arbitration is maintainable or whether Section 9 can be filed. One such issue is that the definition of claim in IBC is very broad. So the definition of claim in IBC is a monetary claim, and it says whether or not it has been reduced to a judgment or order of any honorable court or tribunal. So the definition of claim says that even if your claim is not yet determined by a tribunal, it will be a claim under the IBC. Now, this definition definitely finds some discrepancy with the findings of the Supreme Court in Indus Biotech matter, because this definition will include a claim which is not yet determined. So this discrepancy as to whether my claim has gone in for an understanding by any court, or whether any court has examined and said, yes, I have to have this much amount of a claim. If I am saying that 1 crore debt is due, it becomes a claim and it accordingly becomes an operational or financial debt under the IBC. So as of now, the definition of claim issue has not been decided per se in terms of any landmark judgment. However, there are various judgments being passed by honorable NCLTs where they ultimately decide that the issue is controversial. So this will need certain kinds of adjudication before it can be decided whether there is a claim or there is not a claim. For that, they rely on the Indus Biotech judgment. And lately, what has happened, there has been a judgment in the matter of Vidarbha Industries that has been passed by the Supreme Court that has also changed the scenario a little bit, because Vidarbha Industries now says that the NCLT has the power to examine whether or not a company is solvent or insolvent. And blindly, no NCLT should admit an insolvency petition, putting a healthy company into insolvency. So the determination of claim issue also finds an interplay here, because an arbitral tribunal is a fit tribunal to determine the claim. So therefore now, although in the prior judgments, in the earlier judgments, say between 2016 and 2020-21, it was very clear that the IBC will not decide an arbitrable issue, and IBC will just look at default, or the determination may be by someone. But now there are these questions that have started arising. Now, in this regard, the obvious corollary of this discussion in the pre-admission stage is that suppose there is a party that already has an arbitral award in its favor. Suppose I, as a party, moved a arbitration against a particular company and I have an award in my favor. So can I now use this award to start an insolvency proceeding? So the reason why this became so important is because a lot of these debts that were coming to the tribunals under the IBC were debts that were barred by limitation. However, there was, in some cases, there was confirmation in the balance sheet. In some cases where awards, etc., were passed, where the disputes between the two parties had already been determined, and then and a competent tribunal had already held that there is an amount that is payable, parties started coming to the NCLT with those awards as the basis of the debt, because that was saving them in limitation. So the Supreme Court initially, in the matter of K. Kishan in the matter of C. Shivkumar Reddy in 2021, the Supreme Court initially decided that an award holder who has got an award or a court order from a proceeding like the DRT or any arbitral award will become a financial creditor. However, it was realized later, and these arguments started being made in NCLT, that if every award holder were to become a financial creditor, whereas the underlying transaction was that of supply of goods, so it is not possible to hold that somebody who is an operational creditor, merely by virtue of having obtained an arbitral award, will become a financial creditor, because there is no disbursal of loan, there is no time value of the initial amount that was given. It was given against goods and services, the initial amount which the corporate debtor owes to them. So subsequently, the finding in C. Shiv Kumar has been diluted. C. Shiv Kumar has been interpreted by various courts and tribunals, including the Honorable NCLAT and the High Courts, to say that C. Shiv Kumar was a judgment which dealt with a decree of the DRT, an order passed by the DRT. So the underlying debt was financial debt, and therefore, in such a case, the award made them financial creditors. However, subsequently, in various judgments such as Cholamandalam Investment versus Navrang Road Lines, the Madras High Court has decided that you always have to rely on the underlying debt to decide whether somebody is an award holder, the award holder is an operational creditor, or the award holder is a financial creditor. It cannot be that merely by virtue of possessing an arbitral award, you become a financial creditor. In this line of judgments is a very important judgment that has been passed by the Honorable Supreme Court in the case of K. Kishan versus Vijay Nirman Company Limited. In this case, the Supreme Court was deciding that the award that a particular person holds, can that be the basis of initiating an initiating an insolvency proceeding. And this interplay between an award holder being a certified creditor of the company versus an IBC proceeding where pre-existing dispute has to be decided, that interplay came to the fore and the Supreme Court passed an order on it. The Supreme Court said that in a case where the award is passed for an underlying operational debt, and that award under the Arbitration Act is not challenged in the timeline that is provided in the Arbitration Act, and that award has attained absolute finality. In such a scenario, the Supreme Court says that the award and its underlying operational debt can be a basis for initiating insolvency. However, if there is any scope of any challenge to the award under the Arbitration Act, then it cannot be the basis for starting off an insolvency proceeding. For example, if only 60 days have passed and the time limit for challenging the award is still valid, then there can be no insolvency proceeding that is initiated on the basis of the award. Or if the award has been passed and there is a Section 34 Arbitration Act proceeding that has been filed against the award, which is pending adjudication before any honorable court or tribunal, as the case may be, then in that case, you cannot initiate insolvency proceedings on the basis of the award. So the Supreme Court has held that again, in this interplay between IBC and the Arbitration Act, you have to look at the provisions of the Arbitration Act. You cannot blindly rely on Section 238 of the IBC to say that IBC overrides everything and the award becomes a proof of debt. So the Supreme Court says, yes, an award by an arbitral tribunal is proof of debt because some authority has adjudicated. But the Supreme Court gives due deference to the provisions of the Arbitration Act and says that if a challenge is possible under the Act, which is the applicable Act, then we will wait for the challenge to be decided before IBC takes it as the final word. So IBC is not blind towards the Arbitration Act. IBC is not blind towards what the Arbitration Act provides for the particular statute, etc. So now I'll also point out a problem with this line of reasoning. The problem with this line of reasoning comes at the stage where there is an admission or where there is a Section 34 that becomes barred by law. But there is, for example, provision for the Limitation Act being allowed, or a condonation of delay being allowed under the Limitation Act for certain just grounds. Now, obviously, once the 120 days are over, there is finality. However, till that period, my award kind of, for the purposes of IBC, is a paper decree. Because I cannot take that award and go somewhere with it. I cannot execute that award. I cannot go to the IBC with that award. Now my limitation, once the Supreme Court says I have to come with the underlying debt, I have litigated for 3 years, managed to get an arbitral award. I know that the execution of arbitration will not get me anything, but an insolvency resolution might get me something. Like I said, as a collective remedy, insolvency resolution may be useful to me. But one, I get no priority despite being an award holder because my underlying debt becomes important. Second, it is possible that my limitation for filing an IBC proceeding is running out. And therefore, I cannot wait for 120 days after the award to be able to file an insolvency proceeding. But in terms of the ratio of these judgments, my insolvency proceeding on the basis of the arbitral award will be null and void. My arbitral award will not be treated as defense. So the obvious remedy in that case would be that I move the application for admission, then I delay it till those 120 days pass. So this is a very big problem in terms of initiation of insolvency when there is an arbitral award, and how this arbitral award is to be used in insolvency. The good thing, as I see it, or in my opinion, is that the insolvency laws have not been blindly applied. Insolvency laws have not been interpreted to override every other law which which has existed for so long, which has been a backbone of corporate litigation for so long. So insolvency laws have not uprooted the existing regime. They have just added a very important layer to the corporate litigation regime. Now, somebody has asked in the chat box about the arbitration during insolvency moratorium. So this was the first part where I was dealing with the pre-admission stage, and I was dealing with issues that incur in the pre-admission stage. I will come on to the post-admission stage now. In the post-admission stage, the burning issue that has caught the attention of the entire country is that what happens to arbitration during moratorium. And this moratorium interpretation has also caught the attention of the country because interpretation of moratorium in corporate insolvency, in companies insolvency, is being applied to insolvency of personal guarantors, is being applied to pre-pack insolvencies, which are obviously the up and coming insolvency litigation that we are going to see in this country. Now, delving straight into the provisions of the moratorium, I've had the fortune of addressing the honorable courts, various courts in Delhi, tribunals in Delhi, including the Supreme Court, on the issue of arbitration in moratorium. So I will share my experience first of all. The experience that the most interesting argument that I was able to make in this regard is that there were certain arbitration proceedings against my client, which was a corporate debtor in insolvency. Those arbitration proceedings prior to admission into insolvency had resulted into an arbitral award, and the arbitral award was in the company's favor. So the company had moved the execution petitions under Section 36 of the Arbitration Act in various courts and tribunals throughout the country, wherever the of my debtors were. I had moved, so some of them were in Chennai, some in Bangalore, some in Lucknow. So we had moved these execution proceedings. Meanwhile, because some of these awards were ex parte awards, those parties, when they found out in the execution proceedings, they moved Section 34 proceedings in Delhi against my company. Now, these Section 34 proceedings were pending for the first 3 years of insolvency, where these, because there was information about these cases was not available, the RP for the first 2-3 years of insolvency, the matter went on for a long time because of stay, etc. The RP had not represented the company in these Section 34 petitions. So these Section 34 Arbitration Act proceedings in various district courts in Delhi and in the High Court had proceeded. They had gone to the stage of issuance of notice, they had gone to the stage of deposit, etc. for stay. In some cases, there was even stay on execution. So when we took over as the legal counsels of the resolution professional, we figured out that most of these Section 34 petitions had been filed after I was admitted into insolvency. So we went to these courts and tribunals, various district courts and the High Court. We went and told them that, look, under Section 14(1)(a) of the IBC, institution of proceedings against the corporate debtor is barred. So any Section 34 proceeding will be barred. We are squarely covered by the judgment of Alchemist ARC versus Hotel Godawan in this regard, which says that there can be no institution of proceedings under the Arbitration Act against the corporate debtor. The challenge that we face, this was fair and simple. We did not face any challenge as far as this argument was concerned. The challenge that we faced was that the corporate debtor had moved execution proceedings in various courts and tribunals, or in various courts across the country. Some, like I said, some of them were really far off courts also. The moratorium under Section 14(1)(a) does not apply to a proceeding that has been instituted by the corporate debtor. Specifically, it applies to proceedings against the corporate debtor. So in all these courts where we went and said Section 34 is not maintainable against the corporate debtor, the judges and the other side would tell us, but then you have to put a stay on the execution filed by you. And for that, we did not really have an answer, except that there is no moratorium. So let the execution court decide what will be the fate of my execution. However, that does not affect the stay or moratorium or the rejection of the Section 34 petition. Now, we were able to achieve a lot of orders. Some of them went to appeal in the High Court. We made the same argument before the High Court, which the High Court appreciated. However, before passing of a final order, the company that we were representing was sold off. So there could be no end to those proceedings because Ghanshyam Mishra kicked in and the claims that anybody had, they were all dissolved. So there could be no pending proceedings. So this is a very interesting play on the moratorium, which is a reality because during the period where we were trying to fight this out and resolve this issue, the insolvency process was ongoing. So the insolvency process under the IBC being completed, once Ghanshyam Mishra and other judgments apply, all the claims go, all pending litigations go. Whoever's purchasing my company in IBC, either or liquidation or through plan, they are not to be saddled with litigation that was previously existing. So this was a very interesting, although we couldn't achieve any landmark judgment in this regard. However, it has since come to my attention that there is a very specific judgment that has been passed by the Honorable High Court of Delhi. This is in the case of IRA Infra Engineering, where the High Court has observed that there is no doubt that Section 34 proceedings in exactly similar factual circumstances have to be stopped. They cannot be continued. The moratorium is applicable. However, the High Court says it does not stand to logic that Section 36 be allowed to continue. Without giving a stay by making this observation at the interim stage, the High Court has now posted the matter for arguments. So we are hopeful that this issue will also get resolved ultimately because the interplay after admission, the interplay between IBC and Arbitration Act after admission of insolvency is more complicated than we can see because there are very small nitty-gritties that arise or the issues that arise, they're purely legal and those will have to be decided by courts and tribunals. Now, in this regard, because I've given a detailed factual description, I also want to point out two judgments. There is one which is the Jyoti Structures judgment, Power Grid Corporation versus Jyoti Structures judgment passed by the Honorable Delhi High Court. This is one of the leading matters where it is decided what happens to arbitration proceedings that are ongoing, not cases where an award is passed, such as the one I was describing just now. What happens to ongoing arbitration proceedings during insolvency? So ongoing arbitration proceedings can be either by the corporate debtor or against the corporate debtor. As I said, proceedings by the corporate debtor are not affected and they continue as is, as they were continuing previously. The resolution professional now represents the company in this regard. The proceedings that are against the corporate debtor, they get stayed. There is no doubt on this proposition anymore. There are various judgments of the Honorable NCLAT also that clarify that no proceeding, no arbitration proceeding is going to continue. The complication arises where there is a counterclaim, either in an arbitration by the corporate debtor or in an arbitration against the corporate debtor, meaning whether the counterclaim is by or against the corporate debtor, the issue arises as to what happens in such a scenario. The background of this issue is, for example, there is somebody who has made a claim against the company, filed an arbitration. The company then goes into insolvency. The company says, I have a counterclaim against the claimant in the arbitration, and the company has moved a counterclaim prior to admission of insolvency. Now, that person's arbitration will be stayed because of applicability of Section 14. However, my counterclaim can still be adjudicated because that is a proceeding by the corporate debtor. So now one claim cannot be decided without the other since the counterclaim has to be compositely decided with the claim. So this issue was being dealt with in the Jyoti Structures judgment, where the Delhi High Court observed that Section 14(1)(a) is not an absolute provision. So it is not that Section 14(1)(a) of the IBC becomes applicable and everything has to stop. There has to be a consideration. So they adopted what is known as a purposive approach to Section 14(1)(a). They tried to examine what is the idea behind Section 14(1)(a) moratorium having been introduced. The Delhi High Court reached the decision, or their judgment was that in cases where there is a counterclaim, the arbitration proceedings can continue and the claims can be decided because the claim and counterclaim both will be decided compositely. Now, this was the law that was being followed. This is the law that is generally taken as currently the word on this issue. However, it is to be noted, and very, very few people are able to take this argument in the judgment of P. Mohan Raj, which was a case dealing with moratorium. The case was in considering the facts of the case related to continuation of Section 138 Negotiable Instruments Act proceedings, that is check bounce matters against corporate debtors in insolvency. And there is a discussion on the interpretation of Section 14 that the Supreme Court undertakes. Categorically, in that discussion, the Supreme Court quotes the lines from the Jyoti Structures judgment and makes a one-line observation that the law laid down in Power Grid Corporation versus Jyoti Structures is not correct. Therefore, specifically, it is to be understood that the Honorable Supreme Court has overruled the Jyoti Structures judgment. It is not because the judgment was on P. Mohan Raj judgment was on a different issue. People don't focus on this discussion, but it is to be seen that actually the Jyoti Structures judgment has been overruled. Therefore, this issue is again in the open field to decide what happens when there is an arbitration proceeding and there is a counterclaim. Now, there are some judgments that have since been passed that are trying to deal with this issue, that are trying to manage the understanding of moratorium that was laid down in Jyoti Structures versus the interpretation given by the Honorable Supreme Court. And some of these judgments are the Jharkhand Bijli Vitran versus IVRCL judgment and SSMP Industries versus Perkin Food Processors in the High Court. Both of these judgments have laid a middle ground, which is now widely accepted scope of these proceedings. The arbitration proceedings fate is such that if there is a counterclaim by one of the parties, since one cannot be decided without deciding the other, there is a scope of set off that may happen at a later stage. Therefore, at this stage, the arbitration can be allowed to be continued. If the arbitration is allowed to be continued and there is an ultimate finding in the arbitration against the corporate debtor, nothing comes off. Because the corporate debtor cannot be asked to part with its assets to provide what has been directed in the arbitration. That is squarely hit by the moratorium. So there is a middle ground now that the moratorium is not applicable in terms of continuation of proceedings where there is a counterclaim. If there is no counterclaim, a proceeding against the corporate debtor is barred. It cannot continue. But where there is a counterclaim, the decision on the claim and counterclaim can continue to be taken. And the observation by the Delhi High Court in the SSMP judgment versus Perkin Food Processors judgment was very categorical, where it said that Section 14 has created a situation that has no answer. It's a piquant situation as per the Honorable Delhi High Court. So there is no answer. And therefore, there has to be judge-made law on the issue. To explain this further, I'll also draw parallels to what happens in the US and UK, England and Wales, and I think in Hong Kong as well. What happens in those countries is that suppose there is a pending arbitration proceeding, a company goes into insolvency, their equivalent of the moratorium kicks in, and then the proceeding stops. However, there is a provision that the resolution professional or the insolvency administrator can apply to the honorable court and say that please let such and such arbitration proceedings continue. In that case, those are, if the court so permits, if the insolvency court so permits, then such arbitration proceeding can continue. So that is a sort of a guideline for the midway that has been reached by the Honorable NCLAT and the Delhi High Court currently, that in case the claim needs to be decided with the counterclaim, then in that case, it will have to continue. However, the crucial differences, which is something that somebody has also asked, during an IBC proceeding, the resolution professional representing the company cannot opt for an arbitration. In the US and England and Wales and Hong Kong, they can opt for an arbitration to continue against the company. Whereas in India, there is no such provision to opt out of Section 14(1). So you cannot pick and choose that a certain arbitration be continued. Only if there is a counterclaim, there is a middle way, there is a path that has been drawn out by the NCLAT and also endorsed by the Delhi High Court currently. Now, as far as I have been able to see, Supreme Court has not yet conclusively decided on this issue. So during the insolvency proceedings, during CIRP of a corporate debtor, the two primary issues that are seen are execution of proceedings and whether or not they are stayed or can the corporate debtor go ahead and execute awards, and the fact that what happens to the pending or ongoing arbitration proceedings. These are the two major lines of thoughts. These are the two major issues during insolvency. There is a third issue which is a subset of both of these issues, as to what should an RP or a liquidator do when there is a claim that is received in a pending arbitration proceeding. So currently the RPs and liquidators are acting ad hoc. They are admitting these claims because there may be documents that support the claim, but they're keeping these creditors as other creditors, or they are accepting them as contingent liabilities. Now, there is some guideline available on this in terms of the NCLAT judgment in the East Godavari Breweries matter, where Honorable NCLAT Chennai has said that the RP or the liquidator is not wrong to think of a situation in a counterclaim scenario that there can be a possible set-off. So the RP or the liquidator is not bound to admit the claim as the final claim. The RP or the liquidator can collate the claim. The RP or the liquidator can display the claim in the information memorandum. They can inform the prospective resolution applicants that there is this proceeding pending. However, it is not wrong on their part to keep it as a contingent claim or keep it as a claim which will be decided consequent to the arbitration. Now, what the Honorable NCLAT does not deal with again is the Ghanshyam Mishra situation, where once the insolvency proceedings are decided, what happens to that litigation? That question is still pending as to somebody's arbitration proceedings. What will be the final fate of those arbitration proceedings? If the claim is admitted in the insolvency process, then there is no problem. There is also some guideline on this through a judgment in the Sirpur Mills case, which has been passed by the Calcutta High Court. The Calcutta High Court says that you may have a Section 34 pending. You may have an arbitration, etc., pending against the corporate debtor, which has become stayed due to the moratorium. However, the obligation to lodge a claim in the insolvency or the liquidation proceeding is paramount. So there the interplay of pendency of arbitration has been interpreted with IBC, and they are saying that the obligations that you have to fulfill during the insolvency resolution process under the IBC, those obligations are paramount. Now again, this is in a way interpretation of section 238 that IBC will override the situation. However, the Calcutta High Court in the Sirpur Mills case clearly says that if you have not lodged your claim, then once the insolvency is over, even if your claim was reflected in the information memorandum as a pending proceeding, you are not entitled to get anything. Now, this judgment is pending before the Honorable Supreme Court. So we expect that the Honorable Supreme Court will ultimately make a finding in this regard as to what happens to pending Section 34 proceedings, what happens to pending arbitration proceedings, and how the claims are to be admitted. Are they to be admitted as contingent? Is it really open to the resolution applicant to decide on their own that I will give nothing to contingent claims? Because I may be a sound operational creditor, I may have a very sound arbitration proceeding, and that arbitration proceeding becomes stayed because of the moratorium. I get admitted as a contingent creditor, I file my claim, I get admitted as a contingent creditor. Resolution applicant comes and says, I will pay 90% to OCs, but I will pay zero to contingent creditors. Now, that clause in a resolution plan will be perfectly valid as per the law. So, this discrepancy, the Supreme Court is actually going to decide in the Sirpur Mills case, because the Calcutta High Court says that if you are admitted as contingent or if you don't file your claim, even if you are in the information memorandum, you don't have to get anything. So, this Calcutta High Court judgment has created quite a lot of ripples, been pending in the Supreme Court for a while, and this will really need to be decided at some point in the interest of a lot of stakeholders, because one cannot be put in a worse situation because they initiated arbitration. At the end of the day, Arbitration Act is applicable to everybody, and they're perfectly entitled in law to avail of this legal remedy and go for an arbitration. So nobody can be put in a worse situation because an arbitration has been initiated by them. So this is a very open issue. This has created a lot of ripples, like I said, and this will need to be decided by the Honorable Supreme Court. Now, quickly, I will also deal with the post-insolvency stage as to what happens in case there is a resolution plan or in case there is a liquidation. I'll do this very quickly because this one is simpler. This interplay is actually very clear in the law also. Now, Section 31 of the IBC is very clear that once a plan is passed, it is binding on all stakeholders. So it is binding on the parties that are in arbitration. It is binding on the parties that have challenged an arbitral award. It is binding on the corporate debtor as well. and it is binding on the new management that comes in by virtue of the resolution plan. They have to make proposal for all the liabilities that are there provided for in the information memorandum. So now, once a resolution plan is passed, the only question that remains is the fate of pending arbitration proceedings, is the fate of pending Section 34 proceedings. That fate will necessarily have to follow the applicable law, because the Ghanshyam Mishra judgment, like I've been saying so many times, it's very, very clear. And also the subsequent judgments, the SR Steel judgment and the subsequent judgments and the amendment to the law that says that a new management that is buying the company in insolvency or liquidation will not be saddled with old liabilities beyond what they are paying in the resolution plan. In liquidation, in fact, it is very clear that a liquidation purchaser will not be saddled with pre-CIRP dues at all. Whatever is paid and distributed as per Section 53 will be the distribution, and there will be no saddling of liabilities on the auction purchaser or, in case of a resolution plan, the new management. So the situation in this case is that these pending proceedings will have to go. So here is where my opinion comes from, that the IBC in all its practical aspects, in fact, has overridden arbitration. Because arbitration, which would have taken some time to decide, determine, etc., is overridden by distribution under the resolution plan or liquidation, as the case may be. Because here the interplay becomes one that is absolute. In all of the other, in pre-CIRP stage, whether or not admission should take place, post-admission stage, whether or not claim be admitted, the things are open to interpretation because there is no clear guideline of the law. The law, the IBC nowhere says that even if arbitration is pending, so and so will be done. So that situation in resolution plan is clear because it is binding on all stakeholders. And this is also, like I was mentioning, the Sirpur Mills case. It was very clearly said by the Calcutta High Court in terms of Section 31, which of course will eventually be decided by the Supreme Court. Very quickly coming to liquidation and pending arbitration proceedings, that is also again an interesting fact that most liquidators tend to overlook. Now, the moratorium under Section 14 is applicable to the CIRP period. Once the corporate debtor goes into liquidation, there is a different kind of moratorium that is provided for under Section 33, subclause 5 of the IBC, which says that new proceedings cannot be instituted. This Section 33, subclause 5 is absolutely silent on pending proceedings. So if there is an arbitration that has been initiated prior to insolvency, that was stayed or eclipsed because of the moratorium during the insolvency period, that will come back into the picture and will become an active litigation proceeding, active arbitration proceeding once the company goes into liquidation. And under Section 35, duties of the liquidator, it is specifically provided that the liquidator will represent the company in all legal proceedings. So Section 35 1K, which means that the pending arbitration proceedings will once again become valid, once again become active proceedings once the liquidation starts. So as liquidators, we have to be very, very careful that we don't just deal with them that there is some moratorium, no order can be passed against me. That's absolutely incorrect. Once the company goes into liquidation and there is a pre-CIRP arbitration proceeding, the liquidator is duty bound to defend the company in those proceedings. What the liquidator can do with the court's permission is to initiate a proceeding. For initiation of a proceeding by the liquidator, for example, the liquidator feels that there is an arbitration that can be initiated for the purposes of extracting more value of the assets, the liquidator can do so after permission from NCLT. That's also provided in Section 33, subclause 5. However, any new proceeding will not come into the picture. So whether I am in insolvency or I am in liquidation, nothing can be instituted against me. No fresh proceedings can be filed. But liquidators must take note of this, that once in liquidation, they are duty bound to represent the company, they are duty bound to get the papers, and they're duty bound to defend the company in these circumstances once the company is in liquidation. Now, I will conclude very quickly with a very new aspect that is this far in the insolvency regime, because we were discussing it very broadly, we have not gone into and it is an interesting interplay because there is provision, as we all know, for avoidance of transactions in insolvency. Now, suppose my insolvency has not yet commenced. As a corporate debtor, I am engaged in an arbitration proceeding with a party, and I enter into a settlement agreement with this party. That settlement agreement is concluded. I pay the particular creditor a certain sum of money, and 2 months later, I go into CIRP. So insolvency proceedings are initiated against me. Now, this very much falls under the period for look back under section 66, 43, 45, 50, etc. So, very much this transaction that has taken place where I have settled an arbitration proceeding is amenable to section 43 of the Insolvency and Bankruptcy Code. And that is a really interesting interplay because I would have done nothing illegal as the corporate debtor to have settled an arbitration. I would have done nothing with a mala fide intention. It would be my most bona fide intention that company was going through a problem. One of the creditors initiated a proceeding. I settled that proceeding. However, the language of section 43 is very clear and it has been interpreted by the Honorable NCLAT in the NTL Electronics judgment, which clearly says that neither is the intent relevant nor is it relevant why you settled a certain matter. And they have interpreted, they've read section 43 subclause 3 to say that even if it is done pursuant to a court order, even in that case, the clawback provisions will apply and you can have a transaction avoided. And the reasoning given or the justification that I can think of for such an interpretation or such language being used in the insolvency code, and I go back to the start of my lecture, like I said, insolvency was brought in so that there was a collective remedy so that the whole pie can be shared between people. So the idea is that individual creditors should be deterred from seeking relief for themselves. So suppose I, as an individual creditor, today seek an arbitration relief, even if it is a settlement agreement, I am seeking priority over the others. And if I am aware that this company can go into insolvency, I will not seek such priority because it will get reversed in court over time whenever the avoidance application gets filed. So this is a really interesting overplay where the IBC again has completely overridden a valid arbitration, a valid settlement in an arbitration, or a valid payment of award in an arbitration. So this is a place which is where there is a lot of growing litigation because as of now, the law as it stands in the NTL electronics case as passed by the Honorable NCLAT New Delhi, they have clearly said that even if it is paid pursuant to a court order, if it is within the look back period, we will very much ask for it to be reversed as a preferential transaction. So in various places, it is very clear that the IBC overrides Arbitration Act completely. It bulldozes through what is being done under the Arbitration Act, such as a resolution plan or a scenario such as I just mentioned under Section 43 for avoidance of preferential transactions. However, in the more nuanced places, such as admission of CIRP or in application of moratorium, there is scope for interpretation as to how the two acts can coexist together. And that is all from my side. I see that there are a few questions in the chat box. If anybody wants to ask any questions, we can quickly do a round of questions. Maybe then I can just go through the questions in the chat box. There's a question about the fate of arbitration during moratorium. I believe I've dealt with that and I tried answering it during the information that I was giving. There is a second question. Can parties choose for arbitration while IBC is progressing? Like I said, there is no scope for the resolution professional to opt in or opt out of Section 14 moratorium. The resolution professional is bound that there will be no proceedings. He cannot, by way of a contract, choose that some arbitration proceeding be run. Now, for the RP to go in for arbitration proceedings, it is my belief that he will need a clearance from the COC for the expenses that he will incur. So if he wants to proceed in arbitration against someone else, it can be done by following the procedure of law. There is another question that CD has disputed receivables from a government department and there is an arbitration application that is pending. Yes, so the question is whether the NCLT can appoint an arbitration or they should be advised to settle. if the company is in liquidation, there is no new proceeding that can be initiated against the company under Section 33 subclause 5. So it is not possible that the liquidator again chooses to go for arbitration or the liquidator chooses to go for settlement. If some settlement has to happen, it will have to be, in this case, there's no COC. So in this case, it will have to be where the money comes into the corporate debtor. There cannot be a settlement where the money goes out of the corporate debtor that is in liquidation. There is another question that while cross-claim is pending under arbitration, how can IBC proceeding be settled? So if we are talking about a Section 12A scenario, then Section 12A scenario is where the promoters can bring in a settlement and IBC proceedings get dissolved without proceeding further under the IBC. For that, there is no relevance of whether an arbitration is pending or not, because that is purely up to the creditors, how they vote for it under Section 12A. If we are talking about an IBC proceeding pre-initiation of IBC, then in that case also settlement is a purely contractual issue. If the party that has initiated the IBC proceedings chooses that I will settle and not go for IBC proceeding, IBC to be CIRP to be initiated, then it is entirely up to the parties. And the Supreme Court has also said that the NCLT will not interfere in a settlement or will not force the parties to enter into any kind of settlement. There's another question that where award has been passed in favor of CD during CIRP period, if any other party files application challenging, should proceedings be stayed or will continue? This is a very relevant question because, like I said, it is not open to any party to file a Section 34 proceeding against the corporate debtor. If the award is in favor of the corporate debtor during insolvency, such a party that wants to challenge the award is covered by Section 60 subclause 6 of the IBC, which says that during the period of CIRP, limitation does not count. So their time period for filing Section 34 against the award will be valid soon as the CIRP ends. From that day, it will start. So they will very much be within their right to file a Section 34 proceeding challenging the award. But during the CIRP process, they cannot institute a new proceeding. And like I mentioned, this was dealt with in the K. Kishan judgment versus Vijay Nirman Company, where the Supreme Court said that the award is not final. And therefore, it cannot be said that the award is the basis for the debt. The award will become final only when the proceedings under the Arbitration Act have concluded. Now, there is one more question. In case there is already an order in favor of a financial creditor before initiation of CIRP, said financial creditor is in the process of recovery of the amount awarded. During CIRP, said financial creditor does not lodge any claim. Whether after approval of resolution plan, the said financial creditor can recover its money from the RA. Like I mentioned, this is the exact situation that has been dealt with in the Sirpur Mills case. The Calcutta High Court says that if you have not lodged a claim, then your claim will get extinguished and you will not be able to make a claim against the new management, against the RA, SRA in this case. So you will have to necessarily, if you have a claim, lodge a claim as financial creditor in the insolvency of the company. If you don't lodge the claim, you cannot stay outside of the insolvency proceedings. A parallel in this is in liquidation proceedings where financial creditors have the option to choose to execute security interests, secured creditors. But in insolvency, where there is an RA, there is no choice and there is no option that has been provided to stay outside of the insolvency proceedings, whether you have an award or you have a decree or not. In fact, in that case also, the IBC is completely overriding the Arbitration Act, because that award will just be a paper award or decree in your favor. It will not become something that can be executed at a later date. I think those are the questions. If anybody else has anything else to ask. I hope I've been able to throw light on the burning issues where Arbitration Act has been looked at by the courts and tribunals in our country. And I hope I was able to say
Thanks,
something that were relevant and new.
Thanks on behalf of JIPA organization and participants for your deliberations on pre-arbitration, during the CRP arbitration, after CRP, and during liquidation process arbitration, much with the supporting of relevant and case laws. Once again, thankful to all of you and also Prachi Jodiji, our guest speaker. Thanks a lot once again. Namaskar.
Thanks a lot, everyone. Thank you, Praveen sir. Thank you.
Thank you so much.
Prachi ji, there is a